Can an accused prefer a discharge application in a summons case? Before answering the question, I would like to tell you what is a discharge application. We must understand what is a discharge application. A discharge application is basically an application which is preferred before the Honorable Court for the purpose of praying to the Honorable Court that the prosecution case is very weak and there are no evidences to support the charge which the prosecution is praying to the court to be framed upon the accused. And when there will be no charge upon the accused, there cannot be any trial. For the purpose of initiating the trial, there has to be a charge. But in summon case, it is not the requirement to frame a charge. The magistrate directly inquires into the complaint of the prosecution, and if he is satisfied that there are sufficient ground to proceed, he will proceed. There is no requirement of framing a formal charge. And because there is no requirement of framing a formal charge, there is no requirement of discharge application. But you have the remedy of filing an application before the Honorable Court to stop the proceeding. Because the case of the prosecution is very weak, and if the magistrate is satisfied that yes, the case of the prosecution is weak and there are no evidences sufficient enough, then in that case he can stop the proceedings. However, if the evidence of the principal witnesses have already been recorded, he may pronounce a judgment of acquittal. Otherwise, the stopping of the proceedings will have the effect of discharge. That is the remedy that is available to the accused in a summons case. But no provision of the Bharatiya Nagarik Suraksha Sanhita gives an express right to the accused to file an application of discharge before the Honorable Court in a summons case. Thank you.